everyone. Today our guest is a team from Lloyd Law College consisting of Harshita Raj, Tushar Hazrati and Tanya Jain who were adjudicated among the top 8 teams of the Asia Pacific region in the Red Cross International Humanitarian Law Moot Court Competition 2023 held in Hong Kong. Firstly, many congratulations for your success in the national as well as the international rounds team. Before we begin talking about the competition, I request you to please introduce yourselves to the audience.
Okay, so hello, I am Tushar Hazrati and I am a third year law student in Lloyd Law College, Greater Noida.
Hi, I'm Tanya Jain. I'm a final year student, BA LLB, Lloyd Law College.
Hey, hi Niharika. I'm Harshita Raj and I'm also a third year law student at Lloyd Law College, Greater Noida.
Right. Can you tell us about the structure of this competition and your team composition?
Sure. So, as we know that the moot proposition for Henry Dunant came in June. At that time, we were having our exam, so we started our preparation a little late. But it all went well as we were the winners. In the national rounds, there were only 48 teams. We competed with NLUs. And as for this year, the South Asian rounds were cancelled. So it was direct entry to this Red Cross. And it was for the very first time that Lloyd Law College went for the Red Cross in Hong Kong. So in the Red Cross, we had 22 teams from whole Asia Pacific. And we were among the top 8 teams in Red Cross.
Right. Can you break down the competition journey for us in terms of your preparation? So what can you tell us about your preparation strategy for the moot preparation and the preparation of your mind, of course? It must be a very long journey.
Yes, so like I said that it was a journey for 9 months till the international rounds just happened in March. So it was a very interesting journey for all of us. So we started as a team working on the competition in June, early June. Our all the interest of the team was to finish the memorials in the first hand. So a preparation strategy that we applied while memorials were being done. So we first prepared the memorials much before the deadline. And then we pleaded from the memorials before different sets of judges and of course our mentor. So these memorials, I'd like to share this detail that these memorials were checked for almost 19 times by our coach, Miss Astha Singh. So that is why I see that the memorials were also of such quality that whoever pleads it will have the privilege over any other team. And moreover, while we pleaded from the memorial, so we knew how these would affect us in the pleadings. Then for the international rounds, of course, like there is a lot to arrange for the travel, for everything else. So we had to make up our mind that we'll be traveling. So I and Harshita were traveling for the first time. Like we're traveling for the first time to any international place. And that is why we faced a little issues with how to manage our preparation along with the journey and everything else. But then the best thing was we finalized all our pleadings and all of the memorials, etc., much before the actual dates of the competition. So we had this privilege that we had well amount of time to arrange for everything else. So that is how we kept us cool. We kept distance in how the deadlines and we had to meet. That is how we kept ourselves cool.
Right. So you won the first part, that is the Henry Dunant competition, and which made you eligible for this competition in the international round. So did your approach in preparing for and participating in the international rounds differ from that of the national rounds? And if so, how?
Yes, of course it differed. So in the national rounds, the biggest part is that I'll tell you the major difference. So in the national rounds, it is all about how briefly can you explain your arguments. You only get 6 minutes for each pleading, like per speaker, and 12 minutes for the entire team. So now this is a challenge. How could you speak so much? We had almost 4 counts, and along with admissibility, gravity, etc. All that to be pleaded in only 6 minutes, and 12 minutes for the team. So therein we had a lot of space for the memorials. We could write as much as we wanted to, but then we had to speak only for 6 minutes. And quite the opposite. On the contrary, in the international rounds, we could only write very less in the memorials. It was only 4,000 words, but you could speak as much as you wanted because it was 20 minutes for the team. 20 minutes per speaker rather, and 40 minutes for the team. So this was like a great amount of time. But then only to my surprise, I found in Hong Kong that this was also not enough for any person who wanted to plead. So the only thing our strategy changed was that we spent a lot of time in elaborating our argument for the international rounds. However, for Henry Dunant, we learned the art of precise argumentation, to the point argumentation. That is how the approach differed for us.
Definitely then. So, can you share any memorable moments or highlights from the experience in the international round?
Yes. So I had faced in the second prelim round, we had a judge from Netherlands. So he was a military command, like he was a commander. He was someone from the military itself. So while you are pleading for the war crimes and you have somebody from the military right there, and we were the defendants. No, you were the prosecutors in that round. So prosecuting somebody who's a military commander in front of a military commander becomes really difficult. Now, the cherry on the top of it was that he was speaking English in a manner that Indians have a difficulty to cope up with. Right. So this was a barrier to understand what he exactly said. So, quite to my surprise, I just took keywords from whatever he said while I was pleading, and then I made the correct guesses as to what could be the question. And that is how I coped up with that. So after that, we were really happy that we made correct guesses at all the points in time. But this accent barrier was really difficult. And above all, if it is about the experience in totality, so Disneyland is a must-go place when you are in Hong Kong.
Right. So, what can you tell us about the memorial preparation? Since you said you were always before the deadline, everyone must be very eager to know what was your strategy.
Memorial was in Henry Dunant we had a lot of space for the memorials. We could write as much as we wanted to. So the strategy was that we first took the issue, then we all three of us sat amongst each other, and we got sides. Like I used to be the prosecutor, Harshita used to play the defendant, and sometimes we also took the victim party. What is the opinion of the victim party? Though it's not counted for the pleadings, but we took, like Tanya Didi used to come and go for the victim party. So we tried different strategies as to who we would fight amongst each other, that what could be the best arguments. So we tried to make this team work as a team, but then we also competed with each other as to find different arguments every day. So when we finally jotted down the best points from all the three sides, then we started drafting. So this is, I suppose, the most democratic and the most plausible approach to go about the memorials. And we took collective responsibility of our work eventually. So that is what worked in our favor.
We can see it definitely worked for you, so that's great. Beyond the legal arguments, what non-traditional skills or approaches do you think or do you believe were crucial to your success in this competition?
So it's very crucial to know that moot court competition cannot be like, you cannot get success in moot court competition only on the basis of the law which you are provided with, because it is a academic curriculum and you need to be very thorough with your the facts of the case. So I want to highlight some points of Henry Dunant and as well as the Red Cross, that at some point of while solving the questions and solving the issues, we face that legal points are not enough to defend ourselves. And it mostly happened from the defendant side that we were not enough with the legal provisions that were provided in books and research papers and cases. So at that time, what what traditional ideas that help you to become like be on edge with every other teams from around different places is that when you focus on the nitty gritty of the facts that are provided. So I would like to highlight that means it's a huge accomplishment that our Red Cross mood proposition was drafted by Professor Sten Verhoeven, and he included a part of child enlistment, and it has a very crucial thing that you cannot defend it very easily. Now here comes at that point that Tushar had a very great idea defending the entire legal point with the help of the factual matrix that was given, and he had the same level of thinking that Sten Verhoeven applied. And how we got to know that, it was at the time when finals were done in the Red Cross between Philippines and Thailand was the prosecution. So Sten Verhoeven asked that these children were actually not recruited by the child soldiers, but they were just kept in the family setup. So we were like, oh my God, Tushar had that level of like thinking idea that he was actually playing with the nitty-gritty of the facts. So it is very crucial to get thorough with your facts, and that's the traditional idea you need to apply when you're playing with you're playing in moot courts. That's it. So the next part of this beautiful competition was that what was the learning about from like what we have achieved from the entire competition. So first of all, it is that you need to read a lot about everything you're going through, because IHL is such a vast area of law that you need to be very thorough with everything that is provided uh, in the conventions. You need to you need to have many things on your fingertips, like what are the articles that are provided in additional protocol 1, 2, then Geneva conventions. There are 4 Geneva conventions. So as like what the kind of competition and the kind of question we dealt in the entire competition in the Red Cross was something that you need to have everything's on your fingertip. So you have to strategize your entire preparation, as in your making your memorials, you're pleading, and you're reading as well. And equal time has to be allotted for everything you are doing. So that's the basic learning we have taken it from there.
So I just want to add one thing to what Harshita already said. That one difference I saw in my preparation style, which would, I guess, help all the audience of the show. So it is that in earlier moods, I have blurred out the line of who's a mentor and who's helping me with the pleadings. But in this mood, I made it very specific that I should only listen to what my mentor says. Now, this multiplicity of people telling you things will definitely change your mind throughout the competition, and you lack the coherence in the arguments all the time. The speeches keep on changing. So this is how I have kept myself really tied to the mentor all the time, and I'm really thankful to our mentor, Advocate Asta Singh. Like I used to text her all the day that can we do this? Can we add it? Can we? And she never got irritated from whatever I said. It always comes at a blossoming response that yes, you can do it, you cannot do it. She grilled us in the pleadings, but then she again told us how could we perform better, what could be changed. So this is one strategy I'd like to suggest to everybody who will be seeing this, that always listen to one person. Choose that one person very wisely in the first place. Take all your time, take all the decisions correctly. But then once you have done choosing the person, listen to that person with all your heart. Otherwise, you'll end up being frustrated with whatever everybody is telling you. So that is one thing I have taken as a good takeaway. Maybe it
Right.
helps.
Right. So coming to Tanya, Tanya, as the team researcher, what approach did you have towards the rounds?
Yeah. So, as it was guided by our mentor, we have divided our issues. I prepared one issue from both the sides, and I prepared the compendium for the team, and I helped them with all the cases that they were citing. I helped them with all the research and all the problems that they were facing in their speech. I was clarifying for them. I was like getting all the materials, whatever they needed in their speech. And in the rounds, like as the judges were questioning, they were grilling us in the grounds. So we were changing our approach every time as what we can do next, how we can change our answers, what would be more appreciable. So
Right.
that's it.
Finally, what learning did you say, can you say that you took back home? And what advice would you like to give to the law students aspiring to participate in international moot court competitions, especially those focusing on complex legal issues like war crimes in your case?
Okay, so maybe I can start because we'll all have different views on this. So, at least for myself, I was very clear that international humanitarian law was really to protect only one aspect of our life. That is the life, the way you breathe. That's it. Human rights and humanitarian law are completely different, and it protects the dimensions. Human rights protects different dimensions. So, I took 15 days to understand this very concept. So, this is, I guess, the most important takeaway, that once you get yourself a mood and you start working for it, you should only learn the simple aspect of what distinguishes that law from any other law. Because when we see international laws, it's all tied up. It's all tied up into a beautiful academic pursuit. But then when you distinguish between them, you learn even that these are even more beautiful laws, and these are crafted by diplomats throughout the world, and best of the minds of the globe have actually worked on it. So you learn how beautiful these laws are. So one piece of advice for everybody who's working with international laws, any international law, never try to stick to one author or never try to stick to a particular piece of academic literature. We should always take variations. If you're reading from William Shabazz, also read Otto Trifteler. If you're reading from one author, also go for other authors. Because the beauty of international law is it is very, very interpretative and academic in nature. And it is bound and it is open to all forms of interpretations. That is why I say that it is a vast law. Read more and more about and from different sources. That is my take.
To add up to what Tushar said, I would like to add the thing that about the variations he said that about the authors. Now, I would like to highlight the two main authors he highlighted. That the first one is Otto Trifted, and the second is William Shabazz. So when you perceive reading this books, like when you read Otto Trifted, it is like a simple thing. It's a book containing the entire law in very simple language. Now when you read that, at the first instance you will come to know that there are things that would always give you like attraction towards like only one side of the page, like it is more towards the prosecution side. So when are you taking the case to the court, so it would be like that it is only towards for the prosecutor side. Now when there is a time to defend yourself, I would suggest that you should read William Shabazz, because that particular author has brought things which will help you to defend yourself in the case. And second of all, I would like to say that whenever you take up any moot court competition, whether it is a national moot court competition or an international moot court competition, so try to learn about the organization which is controlling it. Like in this, Rome Statute was the particular book which was guiding the entire thing. And ICC here is an organization which is taking care of all the cases falling under it. So I would like to say to all the students that it is having a very beautiful history, that how ICC came up, what were the uh, two additional courts which led to the formation of ICC. So basically we need to learn all those things. So it's a pretty story that you will read and you will come across, and it's very interesting. And I would like all the teams who will be coming to take up to participate in these competition to learn about the historical importance of the creation of the entire court, because that will bring the beauty and interest in doing the moot court competitions.
Tanya, if any advice if you have for the aspirants?
Yeah. Well, as it's already covered by my teammates, but I would say that try to understand international law, as it is something that you cannot comprehend in one go. And the beauty of international law is that you have so much to read and nothing is set in one stone. So there are so many views for one theory, and the number one skill of advocacy is turning the arguments in your favor.
Absolutely. All right, team. Thank you very much for this amazing session. I am sure this video will be immensely insightful for everyone watching it. I, on behalf of ILCC, wish you all the very best for your journey ahead. Thank you.
Thank you. Thank you so much for having us.
Thank you.